Order. Thank you to all of our witnesses for participating today, and I'd like to especially thank Ranking Member Senator Tom Tillis and his staff for working together on a consensus basis to put together this 6th hearing this year of this IP subcommittee. As usual, Tom, you and your team have been great partners. Let me just lay a framework for my views on this legislation hearing today with a quick story. Imagine this. A talented inventor develops and perfects a technology to solve a problem, a solution that works better than anything currently available on the market and at a lower cost. And she applies for a patent to protect her innovation, and after tens of thousands of dollars in attorney's fees and a lengthy examination process, she is awarded a U.S. patent. She then brings her technology to market. Her invention becomes a commercial success, improving the lives of American consumers and growing her business. But that invention catches the eye of highly resourced corporations who copy it without her permission and incorporate it into their products. With the help of attorneys, the inventor then files an infringement suit in federal district court against these corporations. And in response, the corporations each challenge her patent in separate venues, the Patent Trial and Appeal Board, or PTAB, as well as the district court. And working together, they weaponize their resources and file multiple challenges at the PTAB, knowing they only have to succeed once to invalidate her patent, no matter what the district court might separately decide. After years of time, expense, and effort, the inventor is ultimately stripped of her legal rights. Corporations are free to use her technology and put her out of business. This not hypothetical example is representative of what too many individual inventors in the U.S. patent system are currently facing. A decade ago, the American Invents Act established inter partes review and post-grant review proceedings at the PTAB with the goal to be cheaper, more efficient alternatives to district court litigation for weeding out improvidently granted patents. And unfortunately, across a decade of experience, all too often just the opposite is true. Today, more often than not, very large, very well-resourced corporations use the PTAB as a tool to wear down patent holders. More than 85% of defendants in patent litigation have used the PTAB as a duplicative rather than an alternative form to challenge a patent, often making the very same invalidity arguments in both district court and the PTAB. The issues with these dual-track challenges are made worse by the lower standard of proof used in PTAB, where a patent challenger needs only show by preponderance of the evidence invalidity rather than the clear and convincing standard in district courts. This not only runs contrary to the cost and efficiency goals of the AIA, but it has led to inconsistent results across these tribunals. In other words, over a decade of experience, patent challenges at the PTAB have not delivered on being faster, cheaper alternatives to district court validity litigation. Abuses of this system are also well documented. As recently as June, a Fortune 500 company was able to invalidate 2 patents at the PTAB after a federal district court jury had awarded $2 billion in patent infringement damages against that company. Statutory loopholes like that challenge are allowed to take place even though the company in that case had already been denied PTAB review during the litigation and was currently time barred from bringing such a challenge. These kinds of outcomes weaken our patent system by making it less predictable, less reliable, less effective, which is why I was proud to introduce the bipartisan PREVAIL Act in June with Senator Tillis. We were joined with 2 other members of this committee, Durbin and Hirono. If inventors and innovators don't have confidence in the ability to protect their inventions, they will stop investing in U.S. innovation and take their money elsewhere, take their skills and their innovative capabilities elsewhere, and we will risk the loss of our competitive edge. This bill makes 5, I think, simple reforms to realign how post-issuance reviews work, and I think it aligns them more closely with Congress's original intent. PREVAIL imposes a standing requirement to challenge a patent in an IPR, but not a PGR, to encourage early challenges at the PTAB. The bill requires the same showing for invalidity in the PTAB as required in district court, clear and convincing evidence. It requires patent challengers to bring their validity challenges in either PTAB or the district court, but not both. It limits repeated challenges to the same patent within the PTAB and the USPTO. And last, it adds some transparency and other safeguards to the PTAB while including provisions I've long championed to end PTO fee diversion and ensure the PTO has the resources it needs to ensure strong examination and a strong patent system. I look forward to continuing to work with my colleagues and stakeholders as we move this bill forward this year with Senator Tillis' cooperation. We've assembled a great, talented, and experienced panel with diverse views, and I encourage our witnesses to tell us what they like and what they dislike, what they'd like to see changed or improved. I'll introduce our 4 witnesses in a moment, but for now, I'll turn it over to Senator Tillis.
Thank you, Chairman, and thanks to the witnesses for being here. I had an opportunity to greet them before you got there here. But you know, people ask me what are my priorities on Intellectual Property Subcommittee. The one thing I stipulate quickly is I'm not an expert. Senator Coons has learned more about the law than I will ever know, but we have business problems here, and we have impediments to innovation. We have impediments to creation that if we don't get this right, the United States is going to lose its advantage, its competitive advantage, and we have a serious pacing threat against China. We have a business challenge. We need to resolve it. And I do believe that PTAB reform and patent eligibility reform are 2 key components that we have to look at. The America Invents Act created PTAB, which serves as a necessary backstop to invalidate truly low-quality patents that do not represent true innovation and never should have been issued. The intent of the PTAB was to provide faster and more efficient process and determining patent validity to be an alternative federal district court. Properly constructed and administered PTAB can play a vital role in maintaining strong, reliable, and predictable IP rights. However, we have found that, that much of this intent has been lost since its inception. I think things have changed, and the PTAB has ventured well beyond the original intent of the AIA, and the PTAB has become progressively greater and greater forum for abuse and gamesmanship. For inventors large and small, innovating is a very costly endeavor, both in terms of time and money. Innovators should be able to have confidence in our IP system and the ability to predict, at least to some extent, how their invention will endure the patent examination process and potential challenge once a patent's issued. That's why Chairman Coons and I introduced the PREVAIL Act earlier this year, and this legislation should restore, I think, faith and confidence in the PTAB, and in turn further bolster innovation, the innovation engine that is the United States. Now, my hope for the hearing today, I'll just reflect, I'll deviate from some of my prepared comments and reflect on a conversation I had earlier this week with an IP forum. Number one, I tend to say it in all the hearings, get at the table, don't be on the table. If you want to negotiate and you've got concerns with the current language in the PREVAIL Act, come to the table. Identify use cases where we have to address a potential unintended consequence or a vulnerability. While we fix one thing, we break another. But people need to be open and honest about it. To say that the status quo is acceptable and fair is probably the only statement you can make to me to shut me down and probably not spend much more time talking about it. There needs to be change. But I want it to be balanced. I want it to be instructed by people on both sides of the issue. And I think this hearing can go a long way to that end. But nothing substitutes for the discussions we have in between hearings. It's been about a year and a half since we've had a hearing on this subject matter. We've had a lot of discussions in the intervening time, and I hope all of those on either side of the issue understand that my office is ready. We have a great working relationship with Senator Coons' staff to get this right. And we are committed to getting it right, but we're also committed to moving ahead. Thank you, Mr. Chair.
Thank you, Senator Tillis. Welcome, Senator Hirono. I'd now like to turn to introducing our witness panel. Today, we welcome 4 witnesses to testify about the PREVAIL Act. Our first witness is Lamar Smith, senior consultant at Aiken Gump and a former member of Congress. Representative Smith was the lead sponsor in the House of Representatives of the 2011 American Invents Act that created PTAB post-issuance reviews. Thank you, Congressman. Next, we have Joseph Matal, thank you, who is principal at Clear IP. Mr. Matal was a former acting director and acting solicitor at the USPTO and was Senate Judiciary Counsel during the negotiations and debate that led up to the passage of the AIA. Thank you, Mr. Matal. Next, we have Joe Kiani, a founder, chairman, and CEO of Massimo Corp., a global medical technology company that has invented, developed, and produced innovative wearable and patient monitoring technologies. Welcome, Joe. Finally, we will hear from Michelle Armond, founding partner of Armond Wilson. Ms. Armond is an IP trial attorney with 20 years of litigation experience who's been litigating post-issuance reviews at the PTAB since the AIA was enacted. Thank you, Michelle. The mechanics for today's hearing are simple. After swearing in the witnesses, each will have 5 minutes to provide your opening statement. We'll proceed to questioning. Each senator will have 5 minutes. We will likely do a second round of questioning, timing and attendance permitting. So would all the witnesses please stand to be sworn in? Please raise your right hand and repeat after me. Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Representative Smith, you may now proceed with your opening statement.
Chairman Coons, Ranking Member Tillis, and Senator Hirono, it's good to be with you this afternoon. I've sat where you are 100 times, and this is my first time behind the witness table on this side. I have to confess to you, I prefer to be the one asking questions. Nevertheless, I'll try to answer yours today. I'm tempted to say I'll give it the old college try. That time was long ago and far away, though it reminds me of my freshman year. I planned to major in physics and so took the course taught by the chairman of the physics department. After the first semester, I realized I was sitting next to the future Einsteins of the world, and I was not one of them. Today, I readily acknowledge I'm in the company of real experts on patent law, and I don't pretend to be in their league. 12 years ago, I was in the good company of Senator Pat Leahy of Vermont when our joint effort, the Leahy-Smith America Invents Act, became law. We had been working on the patent bill for 6 years, but had not been able to get it out of committee. Then we both became chairs of our respective judiciary committees in the same Congress, and prospects for the bill markedly improved. One of the centerpiece reforms of the AIA was the creation of the Inter Partes Review System and the Patent Trial and Appeal Board to administer it. Our intention was to provide a quicker, more cost-effective alternative to litigation. Inter partes review at the PTAB was never intended to operate as an addition to litigation or as a tool for those challenging patents to raise the cost of inventors seeking to enforce their patents against infringers. There are numerous statements to that effect at the time, including in the House and Senate Judiciary Committee reports on the AIA and during markup of the bill in committee. I won't repeat those statements here, but I've included some of them in my other written testimony. Like all major pieces of legislation, the AIA has evolved since its passage as it has been subject to the test of practical application. In particular, the Inter Partes Review System has received numerous criticisms that it has not operated as the quicker, less expensive alternative to litigation we intended. Many critics claim, in fact, that it has been a vehicle for the very abuse that concerned us in 2011. I am told that something close to 80% of PTAB challenges are brought in addition to district court litigation, that large companies routinely use PTAB challenges as a litigation tactic, and that almost 1/4 of all PTAB challenges come from just 10 very large petitioners. That is not how we wanted or expected the program to operate. If the goal of the PREVAIL Act is to respond to these criticisms, bring the Inter Partes Review System more in line with our original intent, and prevent it from being used as a tool for litigation gamesmanship, I am fully in support. This would help ensure that startups and small businesses get a fair opportunity to enforce their patents and don't get beaten down by their powerful competitors. Also, I think there has been too much focus since the AIA on reducing the burden on patent defendants and nowhere near enough on what more we can do to support America's innovators. Forgive me, but like the Texas Rangers in their World Series win, we should not take our eye off the ball. I believe strongly that our patent system is the key to our economy and that it will help us compete with China and other countries. Any human system has inefficiencies, but if we lose sight of creating a system that truly rewards investment in innovation, we are really hurting ourselves in the long run. Chairman Coons and Ranking Member Tillis, you have definitely never taken your eye off the ball. Thank you for your well-intentioned efforts on so many fronts to make the patent system more responsible and more predictable. I hope Congress will support efforts like yours to make sure our patent system continues to encourage and protect inventors. They are the ones who help drive the economic growth of our nation. I appreciate your inviting me to testify and look forward to your questions.
Thank you very much, Congressman Smith. Mr. Matal.
Chairman Coons, Ranking Member Tillis, Senator Hirono. It's been a dozen years since the America Invents Act was enacted. We now have a wealth of evidence with which to evaluate these proceedings. Over 15,000 PTAB petitions have been filed, resulting in nearly 5,000 written decisions and over 1,000 appeals to the Federal Circuit. One thing that the data reveal is PTAB proceedings are working well. PTAB proceedings are producing reliable and technically accurate reviews of patent validity. You don't have to take my word for it. A recent academic study that I cite in my written statement reviewed the results of 2 years' worth of appeals from PTAB decisions to the Federal Circuit and compared them to the results of district court decisions. The study found that the PTAB is affirmed notably more often than district courts when it reviews questions of patent validity. In fact, district courts are about 2.5 times more likely to be reversed when they've decided a patentability issue. The study's ultimate finding was that, quote, the most straightforward conclusion is that PTAB judges' technical expertise has aided decision-making on the thorny scientific questions that are endemic to patent law. None of this should come as a surprise. In fact, it would be astounding if the results were otherwise, if having a technical education and a grounding in patent law were not an aid in making patentability decisions. The recent decades' experience thus confirms the judgment of successive Congresses that having a trier of fact with a technical background will produce higher quality patentability decisions. Of course, even a good proceeding can be abused. It's important to have limits on PTAB proceedings to ensure that they're not used for harassment or some other improper purpose. Unfortunately, many of the provisions in the PREVAIL Act go far beyond what's necessary to prevent harassment or abuse. Some of these provisions would cut off what are necessary and legitimate patent challenges. One provision in PREVAIL that I view as problematic is proposed Section 315F. This provision would bar a party from, quote, instituting or maintaining a PTAB proceeding if another review has been instituted. PTAB petitions are limited to 14,000 words. A single petition is generally good enough to challenge about 20 to 25 patent claims. There's no limit, however, on how many claims an applicant can obtain in a patent. Although most patents have fewer than 20 claims, some will have 100 claims. Some patents have hundreds of claims. In addition, some patents have unusually complex claims or disputed priority dates, which also requires further analysis and more petition space. PREVAIL's restrictions on petitions in this particular provision would make it impossible to effectively challenge some of these patents. Another proposal in PREVAIL that I would counsel against is its adoption of a clear and convincing evidence standard. During the development of the America Invents Act, the interest that argued the most strenuously against using clear and convincing evidence was the USPTO itself. As the agency pointed out, during a post-issuance review, it's the same expert agency that it was during the initial review of the patent. There's no reason to require the agency to defer to an earlier decision that's the product of less deliberation and analysis and that often did not consider the most relevant prior art. Another proposal in PREVAIL that could lead to mischief is the proposal to bar the PTAB's consideration of any evidence that was, quote, presented during examination. This would allow an applicant to cite potentially thousands of references in an information disclosure statement during prosecution. Given the time limits on examination, it's unlikely the examiner would be able to meaningfully consider those references, yet all those references would then be immunized against any consideration in PTAB review. The law shouldn't encourage that kind of applicant behavior. Another proposal in PREVAIL that I would counsel against is the proposed standing requirement. The standing requirement would cut off many beneficial patent challenges. It would prevent a manufacturer from challenging a patent when its customers have been sued for using the manufacturer's own product. It would bar parties from responding to vaguely worded demand letters that don't go as far as threatening suit. It would also cut off so-called clearance petitions in which a manufacturer wants to test a patent to see if it's allowed to develop a new product in that space. PREVAIL's standing requirement, combined with its expansion of real parties and interest, would also cut off the operations of the petitioning organizations such as Unified Patents. These organizations play a valuable role in the patent system. Often they're the only organizations that challenge a patent that's repeatedly abusively asserted for nuisance value. In my written testimony, I described the litigation activity of Sport Brain Holdings. SportBrain filed 148 individual patent infringement lawsuits before all of its claims were canceled in a challenge that was brought by Unified Patents. If we had this kind of a standing and RPI restriction in the law at the time, it's likely that SportBrain would still be filing nuisance lawsuits against American businesses today. I see that I'm nearing the end of my time. I'll conclude my statement here, and I look forward to answering the committee's questions.
Thank you very much. Mr. Kiani.
Thank you. Thank you, Chairman Coons.
Your microphone.
Thank you. Can you hear me now? Thank you so much. Thank you. The story, Senator Coons, you told about an inventor. I don't know if you meant the lady sitting behind me here, Molly Metz, but she is one inventor and entrepreneur that lost her patent at PTAB and lost her company to a much larger competitor. Unfortunately, it happens way too often. Strong property rights lead to strong economies. And unfortunately, patents that have less than 20 years life at best to them are under attack. The PTAB, as designed, kills over 80% of the patents they review. And I personally know of U.S. inventors and entrepreneurs that have lost during PTAB and have lost their companies as a result. When I first heard about their stories, I thought, well, maybe their patents were weak. Maybe they should have lost those patents. After all, I had been in 2 major litigation that lasted each about 7 years, and none of our patents got invalidated. Well, it went to the jury, it went to the judge, it went to the Federal Court of Appeals. They even challenged it in the older ways of challenging our patents at the Patent Office, where we had the chance to make changes to our claims to still keep our patents. But none of them were invalidated. Then we sued Apple. Apple filed 33 IPRs against our patents. And we spent $13 million defending them. They were able to kill 80% of my claims. In one instance that just shocked me, Apple's attorneys stitched together 5 or 6 patents, and they still didn't show the inventive portion of our patent that a 30-year veteran patent examiner had used to give us the claims. And how did they invalidate it? Apple's expert said, I would have thought of that. That's all it took for this panel to invalidate our patents. So, preponderance of evidence, that's the problem. I learned later that PTAB, his biggest customer is Apple. Number 1 client is Apple. And I had high confidence in Federal Court of Appeals because I'd been in front of them twice before. So I was hopeful that the Federal Court of Appeals would overturn the PTAB, because how could they rely on an Apple expert to say, I would have thought of that? I was shocked that they didn't. They, unfortunately, I learned, had no choice but to accept PTAB's decision because of preponderance of evidence. This study that Mr. Matal has mentioned, I think it missed the point. The Federal Circuit Court of Appeals is not rejecting PTAB's decision because of their low standards that the PTAB has, which is preponderance of evidence, not because they're expert technologists. The expert technologist was our patent examiner who'd been doing pulse oximetry patents for 30 years. So the law really sets the whole system up, unfortunately, for Federal Circuit to agree with PTAB. And unfortunately, I know many inventors, they wish we could go back to the days where I started Massimo, where patents did have teeth. They were strong. I was able to raise money with it. I was able to employ eventually 10,000 people, monitor over 200 million patients a year. But at minimum, the changes you are asking for will hopefully make some changes where the defenders aren't venue shopping. Right now, they're venue shopping with the PTAB. I know venue shopping is not allowed by plaintiffs, but defenders get to venue shop by going to PTAB, where they know they're going to get the result they're looking for. So without strong property rights, the United States is simply going to lose its economic power to other nations because property rights are key to it. And I hope the PREVAIL Act is a first step we can take to fix this problem. I, more than anything, have benefited from our intellectual property, and I've given back by innovating further and further. But unfortunately, this new system is changing it for so many people that could be the people that will save ourselves from the problems that we have today. These entrepreneurs, these inventors do not have the same opportunity I had 35 years ago. Thank you for your time.
Thank you, Mr. Kiani. Last, Ms. Armond.
Chairman Coons, Ranking Member Tillis, Senator Hirono, and members of the committee. Thank you so much for the invitation to speak today. I am an intellectual property trial attorney, and I have a unique perspective because my law firm, we actually represent both sides at the PTAB, both patent owners and patent challengers. So we have seen kind of the whole system from a lot of different views. So I thought the introduction you gave, Senator Coons, was really helpful. So let's talk a little bit about how we got here. So as Mr. Kiani mentioned, about 20 years ago, all patent validity challenges, for the most part, were decided in the district courts with infringement claims. So when I left law school, I had the honor of clerking for the Honorable Richard Lynn at the U.S. Court of Appeals for the Federal Circuit. And when I left as a newly minted lawyer, that's where I went. I was in the district court litigating for plaintiffs and defendants. So after I'd been in practice for about a decade, the AIA came into effect and the PTAB was created. And that dramatically changed my practice. So in addition to being now at the district court, now we're at the PTAB, and we're at the PTAB all the time. So the AIA has made the PTAB the busiest patent court in the nation. And what happens at the PTAB does not stay at the PTAB, unlike Las Vegas. Most patent disputes are either decided at the PTAB or they are fundamentally altered by the PTAB's decisions. So we've heard a lot about how things are going. Well, this is how I think it's going. So I think overall, the PTAB is doing a pretty good job. They have teams and panels of specialist judges who are not only technically trained, but also trained in the law. So these are people that also clerked at the Federal Circuit or they're pedigreed attorneys, and they are working hard to try to get the right result based on the system that we have. But you know, these are extremely complicated decisions. They're much more complicated than district court because you have the technology and the judges understand the technology, and you also have the added layer of patent law put on top. So it's, you know, not for the faint of heart. So when the PTAB first started, and we were at the PTAB, they had a reputation for killing patents, and there were lots of names. So, you know, it's been a decade. Things have kind of settled down. And so if you look at the statistics now, for patents that are actually litigated and defended by the patent owners, there's about a 59% chance as a patent owner that you're either going to achieve a denial of institution, which means the PTAB's not even going to take a second look, or one or more of your claims will survive the PTAB. And of course, if you can get one claim through or more, that's a win for a patent owner. So, you know, more than half the time, patent owners are winning if they fight. So now that we're a decade in, I think it's a good time to do exactly what you're doing here on this committee, which is let's take a look and see what's working and what's not working. You know, to be consistent with the AIA's purposes of having a faster, more efficient system, there are a few areas where I think you can make some tweaks and get a lot of value. And so I'll bring up a couple here in my comments today. So one issue that I think everyone will agree on is the duplicative litigation. So when there is litigation in district court, there is usually an IPR or a PGR running in parallel. So what you effectively have are the same parties litigating the same issues at the same time in two different courts, and that's wonderful for the lawyers, but it's not really wonderful for everybody else. So there's two thoughts right now. So what the district courts sometimes are doing is they're staying the case to prevent that duplication. And the PTAB has also adopted policies where they will discretionarily deny if they feel that the district court is going to hear the issue first and a jury will decide validity. But both of these approaches are not implemented systematically, and they've been very controversial. No, I mean, nobody's really happy with any of this. So the proposed amendment in the bill to Section 315, which provides that if the IPR is instituted, a party can't maintain the same challenge in another proceeding, that would absolutely reduce that duplicative litigation cost. And the second amendment, which I'll highlight, which we've already discussed, is the burden of proof. So right now at the PTAB, which is an administrative agency, the burden of proof is clear and or a preponderance of the evidence, and the bill would change that to clear and convincing evidence, which is the standard that the jury is supposed to apply in the district court. And this will solve the problem that the Supreme Court recognized in Quozo, which is that in the system under the AIA, you have these two different standards. So you can have the PTAB and the district court, and they can reach different results on the same patent. So I'd like to thank the committee for carefully considering patent reform at this junction, and I welcome any questions you may have.
Thank you so much to all of our four witnesses for your testimony. I appreciate the diverse perspectives you shared on how AIA reviews at the PTAB have in some ways fallen short of the AIA's intent and how Congress might address those shortfalls. I'll start my questioning by exploring expectations and goals of the AIA when enacted more than a decade ago and how the PTAB was envisioned, and then a second round to explore provisions of PREVAIL and solicit your continued feedback. Congressman Smith, as you testified earlier today, the AIA established post-issuance reviews at the PTAB with the intent that those reviews would be an alternative path, quick, cost-effective alternatives to litigation. Have the reviews under the AIA at the PTAB lived up to this intent? If not, why not?
Mr. Chairman, thank you for the question. You're exactly right. The original intent of PTAB was to be an alternative to litigation, not an add-on to litigation as it has become. Going back to the intent, it was very simple. We aimed to make sure that valid patents could be approved more quickly, and we wanted to achieve a balance, if we could, between the lone inventor, the small business, the startup, and the large companies, and between the patent holder and the patent challenger. And over the years, that balance, I'm afraid, has not always been achieved. And part of the reason, as you just said, has been PTAB. And it has been used in ways we did not envision, and that's why I'm encouraged by your willingness to take a look to see how we might tweak the AIA to make sure that we can return to the original intent and we can achieve that balance. Oftentimes, the PTAB and the multiple challenges that are filed are, to me, it seems to be almost in order to harass a company rather than to achieve some good. And I'll associate or I'd like to be associated with comments by Mr. Kiani. I read his testimony. I heard what he said today. The situation he described is exactly the situation we wanted to avoid. He, in my judgment, and I'm sure in his, was clearly harassed. He felt like he was being beaten down by a large company. They filed multiple petitions, cost him, I think I just heard, $13 million or thereabouts. That was not what the original purpose of AIA was. And to the extent that PREVAIL Act can correct that and can make sure that we get back to the original intent, I think it is a good piece of legislation, and I wish you well.
Thank you, Congressman. In fact, if I understand correctly, one of the things you said during the effort to pass the AIA with our friend Senator Leahy was that the reviews were not to be used as tools for harassment.
Right.
Something from that.
Right.
What do you think of the fact that most of the most frequent users of the PTAB are 10 large, well-established tech companies who are using it in addition to litigation?
apparently, as I mentioned, the largest 10 petitioners account for something like 80% of the challenges that are filed. And if I may, you started to quote from what we had as a statement, we put in the record back in the days where we considered the AIA. This is the House Committee Judiciary report, that the PTAB was not to be used as a tool for harassment or means to prevent market entry through repeated litigation and administrative attacks on the validity of a patent. Doing so would frustrate the purpose of providing quick and cost-effective alternatives to litigation. Further, such activity would divert resources from the research and development of invention. I can get into that a little bit more later on, but that's simply to concur with what you said, and I think the PREVAIL Act will take us a long way to restoring the original intent and finding the balance that we aim for.
Thank you, Congressman. Ms. Armond, as you just testified, you have extensive experience as a patent litigator, both district court and PTAB. You had about a decade in when the AIA was enacted, and you've had the decade since. What were your expectations as the legislation was being debated and developed and as it was passed about how the reviews in front of the PTAB would work? And what aspects of those reviews have worked well and what aspects have fallen short in your?
So in terms of making litigation more efficient, the PTAB is very good for what it does, which is it's supposed to be a very limited proceeding. They're only looking at invalidity based on patents and printed publications for anticipation and obviousness, which were generally kind of the defenses you wouldn't want to try to a jury anyway because it's really technical and kind of boring. So they do well and they're very quick. You have an answer in 18 months. A lot of our clients really, really like it. I think the one thing that is bothersome is a lot of clients on both sides are frustrated that they're spending money in district court and on at the PTAB at the same time on the same defenses because people need to press forward on both until they know which court is going to take control of the football on these defenses. So clarity would be helpful.
So in your view, there's a burden of duplicative litigation, and having some clarity, not just discretionary stays, but a mandatory stay would help.
Well, yeah, and if you remember in the original AIA, there was that covered business method review, which has now been sunsetted. There was an automatic stay that actually came with that. So I think there's different ways the committee can consider addressing that. One is, the current amendment. The other is potentially a stay. But I think everybody can agree that having lawyers doing the same thing twice in two places is not a great use of resources.
Thank you. Senator Tillis?
Thank you, Mr. Chairman. Thanks again for all of you being here. I don't know if y'all know there's a presidential debate tonight, so I'm kind of in a debate mood. And so, Mr. Matal in particular, if you happen to want to take a counter view to any opinions expressed, if you'll just raise your pencil or piece of paper, we'll give you equal time. But I want to start with Mr. Kiani. The PREVAIL Act requires accused infringers to choose one forum to pursue their their challenges. PTAB or district court. Can you explain why it's so difficult when you have to fight on both fronts?
Senator Tillis, yes. First of all, sorry, Senator Tillis.
Red means on.
Thank you. I apologize. Yeah, it's very challenging to be in both courts. However, I'm a big fan of the jury because it gets rid of bias. And the jury does a great job handling sophisticated patent cases with the judge overseeing through Markman hearing the claim construction parts. So, yeah, the problem we have, as I kind of alluded to it, Eastern District of Texas was a place that people that wanted to harass companies would go to file patents against them. And that, we have laws now against that. But unfortunately, PTAB, with an 80% kill rate, is kind of like the Eastern District of Texas for defenders. So they always choose that. And then they ask the court to stay the trial till they get what they expect, which is kill your patents. And if I may, since you're in debate mode, I take a different stand where Ms. Armond said, it's a good thing when we get one claim. No, it's not. It depends what claim you get. One claim is not good for inventors. In fact, it's most of the time their weakest stuff that, by the way, the defender is not worried about.
And Congressman, I hope I have an opportunity to ask you a question, but I love the fact that we have someone here so we can actually understand congressional intent. It's amazing how, even with bills that I passed in the last Congress, how people think I intended something different. I said, why don't you just call me up? So I'm glad we were able to call you up and get clear on what you had in mind when you were working with Senator Leahy. Ms. Armond and Mr. Matal, I think this is probably one where you'd want to go in. We're talking about changing the standard from preponderance to clear and convincing. I think in your opening statement, you said you had a problem with it and you gave some history, so I'm going to give you a chance to repeat that. But let's start with you, Ms. Armond. Why is that a good or a bad idea?
I think the question is do we want consistency? So the administrative proceedings, the reason we had that originally is because it was an administrative proceeding, and that is the standard that the Patent Office applied. We have seen over time the Patent Office has harmonized more with district courts because these PTAB proceedings are like mini litigations. So if we want both trials to be similar, having the same standard of proof, I think would be helpful, but also at the same time, you know, it's not going to matter necessarily in every case. A lot of the patents that go up, they're either clearly invalid or they're clearly not invalid. And so it's probably going to only make a difference at the margins, but that consistency, it exists, the Supreme Court has recognized, and the question for the committee is, you know, do we want to be the same or do we want to treat the PTAB more like an administrative agency?
Mr. Matal.
Now, the reason you apply a clear and convincing standard in district court...
Microphone.
The reason courts apply a clear and convincing standard in district court is out of deference to the agency's expertise, out of recognition that a generalist court just doesn't understand the technology well. If the Patent Office granted the patent, you know, you should trust the Patent Office to an extent. Again, when you're back at the agency, it's the same expert agency, and in fact, they've had a lot more analysis of the same claims, and they're usually considering prior art that wasn't considered the first time. An additional thing I'd note is that when you're in the PTAB, you do get a measure of deference for the examiner's earlier findings for the prior art that was actually considered during prosecution. There's a policy under section called Section 325D, where if it's clear that a reference was considered and the applicant overcame it, the PTAB won't institute on that proceeding unless it's a very strong case, and I've frankly never seen that happen. This is a good thing. This policy encourages people to be more forthcoming during prosecution. Frankly, if we really want to fix the quality of issued patents, we need to return to a system where it's more routine for people to conduct a search and a patentability analysis as part of prosecution. The current 325D policies encourage you to do that. You can bring the prior art, get it considered, and then it would be very hard for someone to use it in a PTAB proceeding. If we give people clear and convincing deference automatically, even for prior art that was never considered, that whole incentive goes away. But again, most importantly, the clear and convincing standard is supposed to be about deferring to expertise, and the agency is frankly more expert when it's reviewing these claims for a second time.
Thank you.
Senator Hirono.
Thank you, Mr. Chairman. So patent law is it's a specialty area, and it can be very confusing, I'd say. Ms. Armond, so I can understand what the various standards are. You talk about consistency. So at PTAB, the standard is to overturn a patent is you just need to show by a preponderance of the evidence. That's a pretty low standard. And so you have a lot of patents that are being overturned. And yet when there is an appeal, then the district court will apply a clear and convincing standard to whether or not the patent should have been overturned?
So at the Federal Circuit, they review legal issues and claim construction, which is the scope of the patent, under a de novo standard. So they have very broad discretion, but the actual factual findings that the agency makes, the PTAB makes, those are reviewed for substantial evidence. So that is a very deferential standard for the to the PTAB.
So if PTAB applies a really low standard for overturning a patent, then that's going to be given deference.
So the way I think this will play out on appeal if the standard is changed, so right now the Federal Circuit is looking for substantial evidence under that preponderance standard, that lower standard. So if you change it, it's still, I'm sure, going to be substantial evidence, but they're going to be looking for more evidence more the support under that standard. They kind of review it through the lens of the appropriate, evidentiary standard.
The PREVAIL Act that we're talking about, that's going to change the standard for PTAB to go to a preponderance, to a clear and convincing standard before it will toss out a patent.
Yes. So as I read the bill would change the standard at the PTAB. It would not affect the appellate review.
So I think you spent $13 million trying to defend your patent, Mr. Kiani?
Yes, Senator Hirono.
So you prefer the provisions in the bill that creates a clear and convincing evidence by clear and convincing
Absolutely.
for PTAB?
Because that also then allows the Federal Court of Appeals to then take a harder look at the evidence that the lower PTAB court used.
Ms. Armond, you mentioned a couple of suggestions that you had in your testimony. You didn't mention whether you thought a standing requirement would be also an improvement. Do you have any thoughts on that?
Yeah, so I addressed that in my written testimony. So for that particular provision, what the interests are is you have so when there's litigation, there's often an IPR. But under the statute, anyone can file an IPR, even if you haven't been sued. So there's a public interest in making sure that only quality patents issue from the Patent Office, and then you're balancing that against an interest in patent owners who don't want to have just anybody be able to challenge their patents. Or they end up in litigation and suddenly a lot more patents are getting challenged than the ones that are actually in the case.
I have a chart that shows that the litigation without standing is really a lot of very big tech companies that are bringing all these suits. So if they were required to have standing, then that would maybe limit the number of these kinds of claims brought by big tech companies?
I actually don't think standing is going to fix that. The reason that you see the big tech companies filing so many is because they are the biggest target for patent suits in our country. So those large companies are getting hit with lawsuits all the time, like daily. And so the reason they're at the PTAB is because they're trying to defend all these cases. So I don't know.
Who's bringing all these lawsuits against the big tech companies?
Lots of people. Some are other competitors. Some are individual inventors. There are some people that are looking for nuisance settlements. Like, there's a lot of different players in the space.
So a standing requirement is only going to have limited impact?
I think in some areas it could have a big impact, but in terms of changing who's filing at the PTAB, I don't think so, because if someone goes and sues a big tech company for patent infringement, which does happen every day, sometimes many times a day, then they have standing and they're just going to show up at the PTAB again. So standing isn't going to change that.
So regardless of that, though, it seems to me that in every other court case, standing is a pretty fundamental issue to overcome. So it makes sense to me that we would require that in this context. And Mr. Kiani, would you agree with that?
Yes, Senator, I would. And the big companies, unlike mine, when we're about to launch a product, we look to see if we might infringe someone's patents. And if we do, we don't launch the product. The big companies, I know one of them at least, doesn't do that. So that's why they get sued, because they just take people's IP.
Mm-hmm. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Hirono. We'll start a second round of questions. Mr. Kiani, I'm sorry. Senator Blackburn.
Well, thank you, Mr. Chairman. I appreciate that. Before you go to your second round, I'm just invisible up here. Congressman Smith, always good to see you. And I know your long history on these issues. I loved working with you in the House as we addressed many of these. And our innovators and songwriters and entertainers in Nashville, you were always so good to them, and I appreciate that. I want to start with you, looking at PERA and looking at PREVAIL. When you look at PERA and you see the 4 categories that would be deleted, and then we look at the advent and the utilization of algorithms and especially in some of our healthcare technologies in those fields. With PERA, what changes would you make on that? And then with PREVAIL, when you look at the requirement of challengers having to have been sued or threatened with the suit before they can move forward with PTAB, I want to get your take on these two bills and these two provisions.
Okay, Senator, let me try, but let me first concur with your comments. I enjoyed our overlap in the House for 10 years, and we did work on copyright issues frequently, particularly in regard to music. I wish we had collaborated more on IP issues. I'm sure we would have agreed on those too. Let me start with, I think the legitimate aim of the AIA and the PREVAIL Act is to make sure that the small-time inventor, maybe the single innovator, the small business, the entrepreneur, the startup company, gets cleared title to their patents. Now, that helps the case that you were talking about. If they get cleared title, they can use that patent in ways that, whether it be healthcare or other types of patents, in ways that benefit the American people. But so often PTAB is abused in ways that were not intended by oftentimes large companies, and the small
patent trolls.
Patent trolls, and I'll get to that in a minute. You're right, and the result of that is, because the process is abused, the small patent holder oftentimes is disadvantaged and can't produce the patents, can't produce the technology that they should be able to. And you're right about patent trolls, and I'll make a confession here. When we were writing and passing the AIA, I was really consumed with patent trolls. I was seeing a lot of stories and reading a lot about patent trolls. And I won't say we over-focused on patent trolls, but I'll say we may be under-focused on that small-time innovator and how the PTAB might be abused. We never intended for that abuse to occur, and I think that's one reason, or one thing that the PREVAIL Act can do is to correct that situation, bring more of a balance back to the equation. So yes, patent trolls are still a problem, but we need to make sure that we're trying to give as much advantage to the small patent holder as we do anyone else. And if we do that, we will have succeeded.
Okay, thank you for that. Mr. Kiani, I want to come to you. I have had some concerns as I looked at your background, and I note that you are a very prolific Biden donor.
Yes.
Giving money in the millions to the inaugural committee, a super PAC, and that you've received about $3 million in government contracts after he went in. I know you also received some contracts previously, going back into the Obama administration. But can you guarantee this committee that those donations didn't play any role in the government contracts you've received since January of 21?
I'm actually glad you asked me, because no one asked me when they published those false things.
Okay.
We
well,
sell
that's why
medical.
when we do our research, we ask these questions. It's always good to get the input.
Yeah, so let me, first of all, we sell medical products to hospitals, including VA hospital and military hospitals.
Okay.
We've been doing it since 1998. And it happens that during Trump's time, we got more business from the VA and military hospitals than we have during Biden's period or even Obama's period. So that stuff is just totally false. It has nothing to do with it. We don't go for government contracts. We just sell pulse oximeters to hospitals. That's all.
All right. I've got a couple of other questions on that issue, but my time has expired. So I will submit those for the record. And thank you all for being here with us. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Mr. Kiani, if I might, I welcomed your perspective as a patent holder, as an inventor. You've had an extensive legal battle with Apple. I think we can agree that no independent inventor could afford that cost at a startup stage of their company. What would it mean for inventors if they only had to defend their patents in a single form, either the district court or the PTAB?
Well, frankly, If they had to do it with PTAB, it would be horrible. I think really the forum should be the court. And if we're going to have PTAB continue, they should use the same standards as courts. And they should also allow you, like patent offices used to change your claim so that it still can be a valid patent instead of just taking the whole patent away from you.
Mr. Matal, you've got extensive experience at the Patent and Trademark Office. One of the provisions of the PREVAIL Act, I hope we could agree, is a valuable one, would eliminate the practice of PTO fee diversion, something that I think led to an underfunding of patent examination over many years. In your view, what challenges did the office previously face as a result of significant fee diversion? And would ending fee diversion free up funds to allow the office to make the investments necessary to improve patent examination procedures?
Fee diversion was incredibly damaging to the USPTO in the late 90s, early aughts. It stopped technology upgrades. It prevented the agency from hiring enough examiners. At one point, you had art units where people were regularly getting 8 years of PTA because there was such a delay in even initially examining applications. The AIA, when it first passed the Senate, did have a revolving fund that would have permanently prohibited all fee diversion. That ran into the ancient power of appropriators in the House of Representatives and got stripped out. But the appropriators did make a commitment at the time that they would no longer divert PTO fees, and they've stuck to that commitment since then. The only unfortunate incident we've had since then is when the sequester was done in the beginning of the second Obama term. It was interpreted by OMB in a way that seemed designed to make it as painful as possible, and that took money out of PTO's hide, and it forced cancellation of contracts to upgrade the IT. It probably delayed the USPTO's next-gen IT upgrade by about 2 years. So definitely don't want that to happen again. Everyone should be able to agree that we want the PTO to be able to keep its money and do as high-quality work as possible.
You testified PREVAIL's standing requirements unfair because it would prevent business and the public from challenging low-quality patents, if I understood you correctly. Just to make sure we're on the same page or we understand each other, PREVAIL Act, the standing requirement would apply to IPRs, to inter partes reviews, not post-grant reviews. And if AIA reviews are really about the ability to challenge low-quality patents, why is an alternative having Congress requiring those challenges to be filed early in a patent's lifespan during the 9-month window for PGRs?
You know, the 9-month window, you have to file a PGR within 9 months of when the patent is issued. IPRs are overwhelmingly used because of patents that are being asserted in litigation, and by the time someone even learns about a potential patent, the 9-month window is long expired. PGRs are great, but you know, they're often just simply unavailable for the cases that actually rise up. There's also a problem that in the final drafting of the AIA in the House, they provided they changed the estoppel and made it could have raised estoppel, which means if you raise any one issue in a PGR, you're stopped from all validity issues, some of which, you know, may require discovery or other issues. I think that's also deterred people from using a PGR, something that would be nice if finally got fixed at some point.
Last question. Your testimony states juries don't accurately assess patent validity and are not an adequate substitute for PTAB review. Just broadly speaking, American juries have been deciding very complex civil cases. The Sam Bankman-Fried cryptocurrency fraud case is one I'll just point to, very technically complicated, for hundreds of years, and the jury system is foundational to our Constitution. What makes patent validity so different from other complex litigation issues decided by juries?
I'd probably also argue that juries don't always do the best work in antitrust cases either, but juries are really good at certain things. They're good at telling when people are lying. You know, they can sniff out dishonesty. They're good barometers of what's socially reasonable conduct, but jurors very rarely have any kind of a technical background. And when validity does come up in an infringement trial, it's just one of several issues thrown at the jury. Juries are often resistant to doing a patents and printed publications obviousness analysis. I think I noted in my testimony, one of the most dispiriting things you'll see is watching very skilled trial lawyers prepare for a jury trial. There's tremendous focus on themes and painting one side or the other as the little guy or damaging internal communications. The last thing they focus on is the nature of the claims and whether they are read on by the prior art. Juries and generalist courts just aren't set up to do a precise patent validity determination. That's why Congress, starting in 1980, created ex parte re-exam and has kept refining that system out of recognition that you're going to get a much higher quality decision when you have the technical experts at the PTAB assessing these questions.
Thank you, Mr. Matal. Senator Tillis.
Thanks again, Mr. Chair. Just a couple of quick questions. We'll submit some questions for the record as well. But I do know that there have been some who say that the PREVAIL Act is one-sided, that it's primarily benefiting patent owners. So for any of you, Mr. Matal and Ms. Armond, but for any of you, if you could write into this any provisions that you think address some of the concerns of the petitioners, what would they be? Mr. Matal, I think in advance, I don't think you're going to be showing up at a pep rally anytime soon for the PREVAIL winning in its current form. So this is an opportunity to talk about other things that we should be doing to actually address legitimate concerns, which is what I've asked from the stakeholders as late as this week. So it's an earnest question. I'm looking for a feedstock.
If there's something that I think the Congresses that worked on the AIA didn't expect, it's the issue of PTAB independence. For a long time, it was just accepted the PTAB operates, independently. And actually, when I first started at the agency, James Smith was the chief judge and had a very firm standard on you can't talk to the judges about anything. And unfortunately, the recent report from the Government Accountability Office has revealed that that standard has fallen to the wayside and that there have been substantial efforts at backroom influencing of PTAB decisions. Before 1975, PTAB judges, they were then called examiners-in-chief, were required to be appointed by the president and confirmed by the Senate, just like any military officer above the level of captain. And that's one change I would recommend going back to. These judges, they're deciding important cases worth sometimes billions of dollars. The parties, both sides, have a lot at stake. You want a truly independent adjudicator deciding whether to institute a review and to decide the final case. And going back to the Constitution system of ensuring that independence, presidential appointment and Senate confirmation, I think, recommends it to the role that PTAB now plays.
Ms. Armond?
So what I hear a lot from inventors and innovators is two things. One is a concern that if I go to the patent office and spend money to get a patent, what if I lose it in an IPR and I suddenly have to deal with that? And so I think the standing limitation is, or amendment is aimed at that, but the reality is IPRs are actually very expensive to file at the patent office, like more than $50,000, usually just for filing fees, not even legal fees. So most of the patents that are being challenged are involved or they're kind of periphery to litigation. So the independent inventor can take some comfort that someone is not probably going to be around saying, I'm just going to spend lots of money to hit this one individual person's patent. It's really only patents that are being asserted and trying to be monetized in the marketplace that are seeing these things. So I want that message to be clear. And the other message is what I brought up in my testimony. There's a perception that the PTAB is just there killing patents. And if you actually look at the numbers, it's actually a pretty balanced resolution because, again, you can either get out without a trial, or if you go to trial, it is more challenging. Claims do get canceled, but if you look at it, there's like a 59% win rate for patent owners, and I think that's really good news.
Congressman Smith, any words of advice for somebody who's been down this road a lot longer than us as we proceed with the PREVAIL Act?
Oh, gosh, Senator, you have the experience and the expertise, and I've been a little bit out of touch for the last few years, and so all I can say is that from what I know about the PREVAIL Act and what you intend to do with it, I think tweaks are necessary for the AIA. I think you can improve the system. Right now, in my judgment, the PTAB system is being abused. It's being used to harass. And if I may mention one other adverse consequence on the small-time innovator or inventor that I haven't mentioned so far. This goes back to an op-ed piece that appeared in The Hill last month, and the title is, Can the U.S. Compete with China not without strong patent rights. Frankly, China is our competitor. Russia used to be a distant second. I'm not sure they're a distant second anymore. But the article mentions a statistic that I had not seen before. Let me mention it to you real quickly. It talks about weakening of patent rights and that are disincentivizes innovation and private sector funding. Our share of global venture capital funding has fallen from 82% in 2004 to 49% in 2021. That's a third drop. And when the inventors don't get quiet title, clear title to a patent, they're not going to be able to attract investment. They're not going to be able to invest the resources, funds that they need to bring that patent to fruition if they're just simply beat down all the time. So in order for us to compete with China in all areas, but particularly in IP, particularly in patents, we're just going to have to do a good job of giving quiet title to the small patent owners.
Thank you all again for coming and the time you spent in preparation. I yield back, Mr. Chair.
Thank you, Senator Tillis. Senator Welch.
Thank you very much. I want to thank the chairman and ranking member for working together on this. Also, it's wonderful to see Congressman Smith, and I know that you and Senator Leahy worked very hard. Number one, I just want to say I support your effort to promote innovation here. Number two, anytime we can streamline and make the process fair is a good thing. So I really admire the leadership both of you are providing. One of the concerns I've always had is about the pharmaceutical pricing and the patent system there. So I just want to ask a few questions about that. I know what we're talking about by and large addresses the impediments that folks like Mr. Kiani have had to contend with in the technology space. And, you know, God bless you for working your way through it and accomplishing as much as you did. But I wanted to just, if it's okay, to ask Mr. Matal, you know, one of the things on the standing requirement, and again, this is different in the pharma industry than technology space. But patient groups have, on occasion, been successful in challenging patents that have kept less expensive generics off the market. And I'm just wondering if whether there's any potential for unintended consequences with respect to a legitimate challenge from an advocacy group whose goal is to have access to a cheaper generic that is going to be affordable and effective.
Yeah, there definitely are advocacy groups that bring PTAB challenges even though they haven't been sued. And I believe there have definitely been PTAB proceedings that have canceled some pharmaceutical patents. I believe some of those may have been brought by advocacy groups. The problems with patent quality are actually a lot less severe with life sciences patents for historical reasons. Examination's always been more rigorous in that area, but you know, invalid patents do sometimes issue, and you know, you pay a lot more money for the same drug when someone has a right to patent exclusivity for it. It does affect consumers.
Yeah, I mean, it's not the subject of this legislation exactly, but the patent thickets has been a maneuver that has been used by pharmaceutical companies essentially to stifle innovation in the space of health sciences. And is there anything in this proposed legislation that would help us deal with that problem on the pharma side?
I mean, not really. This is a bill about kind of reining in PTAB proceedings to the extent that invalid patents are improperly blocking competition. This obviously wouldn't help that. The problem with thickets deals more with kind of the unique way claims and continuations practice has evolved in the United States. That's an issue Congress could address. It's frankly an issue the USPTO itself could address. The USPTO had an initiative about a year ago to improve robustness and reliability of patent rights that started to look at some of these issues. Should there be, you know, a right to bring and then seek an unlimited number of continuation patents from just one patent?
Okay, thank you. I know one of the parts of this legislation is about the fee diversions, and I guess from 1990 to 2016, more than $1 billion in collected user fees were diverted out of the patent office. And my understanding is the authors here would have that, you'd end diversion, right? Yes. Pretty good idea?
Yes. Fantastic. I just hope you can talk the appropriators into it.
So
I am one. I think I can talk myself in.
Well, I think I would support that, but so essentially, this has been a catch-all cash box for other purposes. I'll ask you, Mr. Kiani, because it's extraordinary what you've accomplished, and I mean, it was bone-chilling to me to hear that you guys spent, what was it, $13 million?
Yes, sir.
In fighting Apple, and what was the beef Apple had with what you did? You were going to be a competitor?
Well, the story is this. In 2013, they called me. They said, you're the platinum of non-invasive monitoring. Please come visit. We'll sign your NDA. Tell us everything. And I did. Instead of working with me, they hired 25 of my people, my engineers, and then they released a competing product that has my trade secrets and my patented inventions. So then when we went to sue them for patent infringement, they filed 33 IPRs on my patents, 6 on just one of them. You know, Chairman Coons, Senator Tillis, Ranking Member Tillis, asked the question, are they going too far with this legislation? And I have inventors here behind me that says they're not going far enough. Lawyers always say bad facts make bad laws. Well, I know the trolls and some issues that was happening around the time of AIA created PTAB. PTAB is not good. A lot of people wish PTAB would go away. The ex parte re-exam process worked. And unfortunately, now you have a system that is getting rid of our properties. We can't rely on them. Mm-hmm. Companies I invested in, an MIT graduate that had this incredible idea how to make AR glasses, was ahead of everybody, fearful of IPRs against his patents. They had to fold shop because they were afraid the big companies were just going to run them out. That's how bad it's become, sir.
Yeah. Well, thank you. That's an amazing story. But thanks for hanging in. Thank you all. And thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator Welch. I'd like to thank Senator Tillis again for being a great partner on this hearing. I think this was overall an important hearing to sort of air out concerns about the PTAB and the ways in which it's working, not working, working in ways other than the co-sponsors, the lead sponsors of the bill intended. I also think this reinforced why the PREVAIL Acts needed to promote fair treatment for inventors and improve efficiency and ensure the PTO has the resources it needs to effectively administer a patent system that actually advances innovation in the middle of our global competition. We've received a number of letters from stakeholders, including from AIPLA, C4IP, the Alliance of U.S. Startups, Inventors for Jobs, Unified Patents, Beyond Inc., Dr. Josh Makower, and a coalition of associations, including inventors, patent owners, large companies, small companies, and academic institutions. Without objection, I'll submit all those letters to the record. Members of this committee can submit questions for the record for the witnesses, which are due by 5 p.m. 1 week from today, November 15th. With that, I'd like to thank all of our witnesses today for your preparation, your participation, and your contributions. And with that, today's hearing is adjourned. We are going to run and vote.